Good morning and welcome to our May 2nd, 2022 strategic planning meeting. It is 9 o'clock. Let the record reflect that all three commissioners are here. I believe Commissioner Kearns is on Zoom, so he's not in the conference room with us, but he is here and participating, and our executive management team is here also. So I am going to let Mike Sparberg start off today.
Good morning. I'm here to talk about some of the projects I've been evaluating under the MacArthur grant. And one of the projects that I've been looking at is the supported release program. In evaluating that, I spent several meetings with the prosecutors, public defenders, district court, Judge Maurer, and the sheriff. And the sheriff kind of gleaned onto this project for the SRLJC. He wanted to, move this forward. And then looking at what was already in place and making some modifications to it, including some collaboration from some of the different areas, I think there's a path moving forward. In looking at this project, it's pretty much going to be just have you bring up the chart, Ron. It's probably easier to explain it up the flow chart. If you look at the flow chart, can I have the mouse? Mouse, man. So, really, Colin has some work on the front end of it, and that's going to be, looking at the ones that are going to receive a low bond, $1,000 or less, or up to whatever we design as part of the program. He's going to in turn have someone to make referrals to the third party provider that we'll have go out for RFP on. Once he's determined the cases that can move forward, you'll see the third party vendor picks it up here. They look for eligibility in the pilot. They conduct a needs assessment on what type of needs that they need as far as to be successful in the program. And then they make the referral to district court along with the public defenders. You'll see that they connect down here. The courts will have these records, of course, the court records. They'll have the referral from the third party. They'll have a pretrial report, and then they have the prosecutor's input as well. And then it will come back, be presented to the court. District court can hear it. They can decide whether to release under those conditions or not. It's totally up to the district court. And then going back, moving to my office right here, I will track and monitor, the reports and all that has to be reported to the MacArthur Foundation. And then in turn, the third party will let the courts know if there's non-compliance or they're not following up with some of the directions they want to show. So this is kind of the flow chart for that designs a program at a high level. There's a lot of work that needs to be done. I have done the work on the RFP to recraft that. I'm working with Victor on that part of it for the third party, and I have redesigned the charter of the program. There's some modifications on that as well. So there is a path moving forward, and I think that we have the congruence that we need, but I would want to hear from the stakeholders that are involved. So
would you introduce the stakeholders that are here
yes.
on the Zoom today with us?
So stakeholders, Amy, of course, Judge Maurer is the big stakeholder in this, and she is on. The sheriff is also a stakeholder. I have Colin Charbonneau, who is from the public defenders, and I have Steve Bartell down there from risk management. And if you guys recall, these are conversations they had earlier on, some concerns that had rose up, and there was definitely some further conversation that need to be had before we could move the project forward. Go ahead.
Prosecutor's office.
Yeah.
Larry just signed up.
Larry is there. I didn't see his name up there. He just signed on. Larry, are you on?
Yes, I can hear you.
Okay. And Larry is from the prosecutor's office. So I think what we'll do is start with the sheriff, because he kind of through the SRLJC took a particular interest in this project.
Well, my interest in this project got thrown at me because we got a false claim that we weren't doing anything with it. And I'll be dealing with that at noon with this folks review, because I want to call them on it. Right now, in my opinion, the judges could already be doing this. It's nothing more than OR with programming. The only problem is we don't have the programming aspect. We have MacArthur willing to pay money to find that programming aspect. You already heard my white paper rendition, my recommendations, they haven't changed. I would try to run it for a year, a solid year and a half, if we can get them to actually give us a year and a half of funding and see how it works. We know how it's working around the rest of the country. It's really going to be on the courts to make sure that they're releasing the right people into the program. And again, they can already be doing this because it is really nothing more than an OR. So I haven't changed any position.
Colin, do you have any thoughts on it? Oh, I'm sorry.
Yeah, so let's see, when we talked about this a couple months ago, you had expressed some, I think, very legitimate concerns about how the program would be structured and administered and stuff. Have you been able to address those concerns? I mean, are you comfortable, or are there still lingering concerns that we ought to be aware of?
I really don't see any lingering concerns as far as structuring the program. The structure of the program is going to be based on what MacArthur has requested. And it really comes down to the courts and the courts making the proper release decisions. What I learned at the last Law and Justice Council meeting was, because I know we don't have a risk tool, and we've always been working to find a good risk tool, but I was told definitively that nobody wants a risk tool anymore. Ultimately, because people claim that it creates more disparity. Folks, one day we'll realize that we don't arrest people based on color. We arrest people based on the crimes they commit. We incarcerate based on crimes. We hold based on crimes. That's what the system is designed to do. And any system that would do otherwise would be automatically smacked by DOJ, and the people making those improper decisions would go to prison. So I have no structural concerns. I don't see any liability issues, since the court could already be releasing these type of inmates, because they are going to be very, or should be, low-level inmates. My only concern is I hope that the courts are receiving the proper information to make the release, because without a risk tool, pretrial services needs to make sure that they're giving the judge a clear and accurate picture of what the individual looks like as far as their history.
Well, and we've spent several years trying to find a risk tool that would meet the needs of the courts and the other elements of the public safety structure, and have not been successful at doing that and stuff. And so, is there still ongoing efforts to try and find a risk tool, or are we moving away from that and to a different structure?
Based on the input that the courts gave, we're not even looking at risk tool anymore.
Right.
We're approaching it differently. We want to make sure that the courts have all the information they need to make a good decision. That's the course that we're gonna head on.
Okay.
The devil's in that detail, though, Commissioner. Define what it is that everything that the court needs. That's what a risk tool is designed to do. The nature of a risk tool is to provide all that information and to give a clear picture of the risk this individual poses to our community. So that's why, the devil truly is in that statement of, does pretrial services have the bandwidth to provide the judges, and the judges are really going to have to help pretrial services along with the prosecutors and defense to come to a clear understanding of, here's all the information we need to get to the judge.
Well, I just want to thank you for all your efforts. I know you picked up the ball and ran with it to try and put this together, and I really appreciate the collaborative effort of bringing everybody together finally, after about a year's worth of jibber jabber, we finally now have a program we can move forward with. Thank you.
Colin, did you have anything you want to talk about?
Just a second. Commissioner Kearns.
So I'm trying to find the white paper that the sheriff drafted. I can't seem to find it in my email, but I think I remember some of the stats in there. So but I do want to ask a couple questions based on the data that you had collected, which I thought was great because it was data that we hadn't seen prior to you compiling that, Sheriff. But you said something about you said something to the effects of, I mean, these are people that otherwise would be released on OR or could be released on OR, but the thing is they're not being released on OR, which would lead me to think that the judge is seeing something that is telling them not to release them on OR, and that's why they're assessing some amount of bail. Your white paper, if I remember correctly, said in New York, which is what this pilot is based off of, is a program or a system out of New York. And in New York, I believe the number was of folks that were released on this supervised release, supported release, that 23% of those individuals committed a felony before returning back to court on the charge that they were allowed on supported release, and 41% in total committed another crime. I mean, it could have been felony, could have been another misdemeanor. I think this is just one of those things where, I mean, you get what you measure. Yes, the failures to appear went down, but I mean, I think 41% of those people potentially victimizing another member of the community doesn't seem like a win to me. That's sort of where my concern is. I mean, do you have any concerns on those numbers?
Yeah, let me address those concerns as they came in. As far as them not being released on OR right now, they are being released on OR. These people are being released on OR. This gives the judge two forms of basically release on recognizance. One, a plain OR with no programming, and an OR program, if you will, with programming. So they're both are on the same plateaus as far as risk, or they should be. That's what I would hope would happen. But that is, again, going to be up to the court to make sure that they're releasing the proper people. So this just gives the court a different angle of, release with on own recognizance or release on own recognizance with programming. That's really what this assisted release program is. Going back to the second aspect, failure to report really didn't go down for people on this program. Matter of fact, you had a better success rate for people that were out on bond. And there's a reason for that. The people that have bond have skin in the game. People that are released under assisted release, because I remind everybody, no one's reporting back to the courts if they have minor violations here or there, or they're not going to their programming. The only way the court finds out that things have gone bad is if they get rearrested. That's the only way we find out that if they've failed, because if they're not going to programming, the programming arm is not going to be reporting that. The other side of the equation is in New York, their failure is they're releasing some very heavy hitters, people with extensive felony backgrounds into this system, and they are the ones that are committing very heinous crimes back into public. So it goes back to what I've said. My only concern is it's going to be the court This is really on the courts to make sure that they have all the information they need to make this decision and release the right people into this program. Based on my analysis of the data of the people that would qualify for this, there's going to be very few people released in this program because we just don't arrest those type of individuals and hold them in the Spokane County Jail that would really qualify. We don't even arrest them. We give them tickets. Or we take it through the court as far as an affidavit. We do not arrest these folks. The ones that do get arrested are during that time frame. We had to get them off the street. Once they get in custody, the judge can take a look and make sure that, all right, maybe we're having a mental health issue, or you were having a severe drug issue that day that you got arrested. We're going to take a look at your total history. Yeah, it looks like you qualify because it's a very low level crime that you were arrested for, that you would fit into this this niche of OR with programming, which you'd think mental health and drug abuse, if we get people into programming, that should help us. But it's really going to be how well the program is operated, but the judge has no true hammer to make sure that they are going to programming because it's all pre-trial. So I don't have any true worries, because if the right people are being put into the program, one, we don't arrest that many of them and it shouldn't be a problem. And two, if we're putting the right people in it, it should be successful. But again, it all comes down to who is put into the program.
Okay, and I did find your white paper. Thank you for Ron sent it to me here. So what the line that stands out to me is it says the 41.3% of New York City supervised release defendants rearrested for all types of charges, including misdemeanors, non-violent and violent felonies, before the disposition of their cases, compared to 18.5% for bail set and 20.4% for those released on their own recognizance. So it seemed this program, there was a higher likelihood that someone was going to get reoffended if they were released on this than either of the other two. I mean, we're saying this is sort of the middle ground between recognizance or own recognizance and bail, but it seems you give someone that middle ground, greater than 40% setting them up for being rearrested. I mean, you'd think there'd be some sort of correlation with this being the middle ground. The percentage would be in between bail and own recognizance, but it's more than, it's more than double of the bail individuals that had bail set at 20.4. It seems this isn't a program that is really setting people up for success. And I don't know why that is. There's probably many things that play into that. So.
And Commissioner, I would agree. It really comes down to who's being put into the program, and that's the judge who makes that call. If we're putting the proper people in, this should be a success. But I know what's happening in New York. They're putting people that should not be in those programs. They should not even qualify to be released under that program, but they are releasing them under that program. And, hopefully, what happens in New York happens in New York. What happens in Spokane will happen in Spokane based on our judges not putting the wrong people into the program.
So I see Judge Mowers raised her hand. So Judge, I'm going to let you go next.
Thank you. First, I want to thank everyone for inviting us to be at the table this morning, as well as Sheriff Knezovich and Mr. Sparber. We've had some really good conversations about the programming and, exactly what's the intention is over the last month or couple months. So I appreciate the time they spent in meeting with us and discussing that. I think first, it's really important to recognize that there are some constitutional as well as some court rules that the court is bound by in relationship to this program. I think we can all agree in this room that we love the Constitution and we honor the Constitution. And what the Constitution says is that if you're arrested pre-trial, you have a presumption of innocence. And so it is from that constitutional prerogative that CRRLJ 3.2 really the meat of CRRLJ 3.2 comes from that. And what CRRLJ 3.2 states, which is what all judges are bound to follow, is that unless the crime is a capital offense, so a murder case, the presumption is release, is OR. There are two categories in which judges can impose bond, but the presumption is, so judges start with the required presumption of OR. If a person either has a demonstrated chance that they may go out and commit another violent offense, so not just an offense, but it has to be a violent offense, then the court can impose bond. Or if the court has concerns that the person will not return, then the court is authorized to impose bond. There's an additional factor, which is the court has concerns that the person is going to interfere with the administration of justice. So you're talking about generally witness tampering, those sorts of things, which we don't see a lot. So if you start from the constitutional presumption of release, and then you look at the factors that are presented to you, the judges look at the factors that are presented to them at first appearance, what we're looking for is, based on this person's history, is there a likelihood that they're going to go out and not just commit a crime, but commit a violent crime, or whether or not they're going to not appear for court? Or witness tamper. Only under those factors can the court impose bond. And so what you have is a system in which, up until recently, the options that the court has was OR or impose bond. That was it. And I think really what this program is aiming to do is to just find another option for the judges to have at their discretion. I think it's important to also note that this program is vastly different than what New York is doing. As Commissioner Kearns indicated, you measure what you put into it. So what was New York putting into their model? They're releasing felons. They're releasing violent felons, honestly, from the material that I've seen. Those folks would not qualify under the terms of the agreement between MacArthur and Spokane County. They wouldn't even be in the pool for consideration. And the reason for that is that the only condition under the pretrial release programming as it's been put forward in Spokane County is that the court orders the person, so in order for the person to qualify, the court has to be able to only order no new criminal law violations, that they meet with the pretrial release case manager, that they timely appear for court. So what that means is, by virtue of those conditions, anyone who the court has to put additional conditions upon, they will not qualify for this program. So if you're talking about our highest risk offenders, DUIs, DVs, those folks will not qualify for this program. Arguably speaking, there may be a first-time DUI offender who has no prior criminal law violations. But right now, those people would be OR'd anyway, with essentially no new criminal law violations, don't use, possess, consume, and come back to court timely. But if they have a protection order, they will not qualify for this program. If they're ordered an ignition interlock device because they've had prior DUI convictions, they will not qualify for this program. Nor are we taking anyone on a violent offense. So I think it's, you're going to measure what you put in. And the pool that we're looking at is, as the sheriff indicated, vastly different than the pool that was utilized back in New York. In addition, because I also thought it was interesting, the percentages as represented in the article that Sheriff Knisevich sent around. And I equally think it's important to note that, so when you talk about folks on supported release doing more poorly, say, for example, than someone who's OR'd, straight OR, well, that makes sense logically, because if the court is straight ORing someone, they are at such a low risk of either committing a new offense or not coming back to court, that the court has said, we have we have no concerns that you're going to come back to court and you're going to do what you need to do. So we're going to straight OR you, release you back to the community. We would expect those people to do well. Elsewise, they would not have qualified for straight OR. In terms of folks on bond doing better than someone who might be released to a supported release program, I thought that was a more challenging question, but if you think about it, it also has some factual components to it. So if a person can post bond, even $1,000 bond, which to you and me might be a minimal amount, to someone sitting in custody, that's a significant amount of money. So what that says is if they can post that bond, even $1,000 bond, much less a $5,000 bond, they have access to resources. They either have a job, they have a family member, they have someone who's going to post that bond for them, or they themselves have enough resources, they can post that bond, which means that they have protective factors, which stabilizes them in our community. And so we would also expect those folks to do better on pretrial release than someone who might not have those resources. The population that I think the judges are most interested in is really folks who are sitting in custody because they have challenges coming back to court. And I think Sheriff Knezevic is correct. Theft charges, driving with license suspended charges, those are not typically arrested. They're cited and released by the side of the road. However, they're given a court date and then they don't show up for that court date. There isn't a big risk that they're going to potentially go out and commit another violent crime, but there is a greater risk that they have challenges that keep them from being able to appear in court. And what we all know is that those failures to appear cost an incredible amount of money because the courts then issue warrants. They then are picked up on those warrants, they come in, they sit in custody until a judge sees them, et cetera, et cetera. And so prior to this, and who knows, I mean, right? This may not be the silver bullet that fixes everything, but it does give the judges another option that when we see those folks who have, not been coming to court 3-4 times, and the judges have to decide, okay, are we going to hold you at $130 a day? Or are we going to try to link you to services to get you those protective factors like employment, like housing, like transportation, so that we can get them in court and we can get those cases resolved without there being 3, 4, 5 warrants that are issued between the time that they're cited by the side of the road, because even law enforcement has determined this is not the kind of crime that rises to the level that we're going to put you into custody. From the moment of that charge, that is the determination has been made out in the field by law enforcement. So how do we address when they just don't come back to court? And that's the population that the court is really trying to get our arms around, because it's very expensive the way that we are currently handling it. Hopefully it works. And I do assure you that the judges are well aware of the community safety concerns. Certainly, we don't want to be releasing folks that go out and commit other violent crimes, or really any crime, but under the court rule, what judges are required to look at specifically at the time of release is another violent offense. We also live in this community, raise our families here, and are equally concerned about those things. So it's not something that they're taking lightly, or certainly look at as just as a mechanism to just release people without that reasonable review. We did have a risk assessment tool here in the county for a while, and I apologize, I can't think of the name of it. But actually what ended up happening was that the judges found that often or at times the recommendations as to release did not match the information that we already have available to us. So the Office of Pretrial Services does a great job in providing NCIC history, which is national statewide history. They also do an interview with defendants before we see them. So we're getting good information about whether they're employed, whether they have community contacts. We also have access to discus jabs, which tells us their local history. And of course, their public defenders are going to, add whatever additional information that might not be just readily available in the data that's collected by the court system and law enforcement systems. But even with that, the challenges that we had with the other tool we were using were that it often, at times, would come back with a release on a charge the judges just didn't feel comfortable releasing on, and vice versa, maybe holding someone when their FTA history was not really indicative that that was needed. So not sure what happened there, but the courts are getting that information and are taking it into effect. And the one that we were using had challenges that the judges quite honestly didn't feel comfortable continuing to move forward following.
Thank you, Judge Bauer. Ozzy has a comment.
The one thing I would caution though is just because we didn't arrest doesn't mean that we wouldn't have arrested. Since I've been an employee of the Spokane County Sheriff's Office, we have not arrested the people we should be arresting. I mean, we don't arrest people for assaults. And I found that out during my training time here during the FTO program. Any other community that I've ever worked in, I've worked in 3 others, that's an automatic arrest. You go to jail for assaulting somebody, not in Spokane County. And Mike will tell you that we actually have policies that, depending on the level of crowding at the jail, we have to call into our sergeants if we're out on patrol, getting ready to arrest somebody, and go, can I get a booking exception? And it really depends if we get that exception or not, how serious the overcrowding is at the jail. And we rarely arrest people that we want to arrest, but we don't because of the situation we face at the jail. The system has basically put the onus of OR on us. And we're being sued for that right now. You all understand that, correct? We're being sued for that right now. So there's the misnomer of, well, just because the police officer or the deputy didn't arrest means that it wasn't an arrestable offense, or that this is an individual that they thought safe enough to release into the community. That's not the case. That's based on how crowded that jail is.
Yeah, just for a point of reference, what Ozzy's referring to is our booking matrix. And it was an agreement with the district courts and the municipal courts. There are certain charges that we could OR on because of the space in the jail. And you're probably aware that we've been on red light status probably twice a week because we're having to have releases happen before we can put bodies in the jail, literally. And so what that does for us is it helps us control the population so that we don't fill the jail up, twice full of what it is right now. So not that we wouldn't, and we do grant exceptions on it. The deputies are good at articulating that. They would say, Mike, this guy has got to get off the streets. He's causing continuing problems, or those sort of things. And of course, we're going to book them. The sergeants will work with them. But it's our gauge. It's how we control it on the front end. So thank you, Ozzy.
And the county just paid $1 million also because of our inability to hold people that should have been held in the jail. Mr. Murray should have never been released in 18 minutes. He should have stayed in jail. And if the jail was working in a proper fashion, the jail's design has programming and everything to deal with that type of case. We created that specifically to take somebody to jail to get them stabilized and then release them once they've been stabilized into a safety net. It's no longer working for them. So our system, it just costs us $1 million. And my concern is, and Larry, if you wouldn't mind talking about the court rule on bond, because you have your own thoughts on that issue, because Constitution doesn't say presumption of release, it says excessive bail. That's what the 8th Amendment actually says.
Yeah, sure. I was going to point that out as well. It's a court rule that says that presumption is release, not the Constitution. The other thing on that is that I know the judge made a point of saying several times that not just any offense, a violent offense, The court rule points out that when they talk about violent offense for purposes of release decisions, that it's not limited to those offenses in the state of Washington that are classified as violent. It leaves it more open than that. It doesn't have to be a statutorily defined violent crime. It'll be up to the judge to determine based on the plain language of the court rule. The other thing that I thought I wanted to point out, and we've had numerous discussions, as you all know, about this. I've talked with Steve Martell. I've talked numerous times with the sheriff, numerous times with Director Sparber. And if there is no risk, a judge is going to OR somebody. So of necessity, if someone on the bench is considering this program, they've assessed some degree of risk. That's just the nature of it, because if there is no risk, they're going to release them on OR. Supported release for misdemeanors isn't going to carry typically that much risk. There is risk, though. Yeah, the county has to understand that there is some. But the judge pointed out that mostly the people that would be on this program are people that have challenges with reporting back to court. Anything from they forgot to they have so many court dates that they became confused, or they couldn't navigate their way around the county. Where this program isn't going to address that is the judge doesn't get to know whether or not they participate in any of the programming. They meet with a representative, they agree to do whatever it is that they're being asked to do. And after that, it doesn't get reported to the judge. The prosecutor doesn't hear about it. So I don't know that this program will help people with challenges to return to court when the court doesn't even know whether or not they actually participated in the programming. And speaking of programming, one of the concerns that I had, and I think it's a fair question, is in the meetings that I attended, Excelsior had been at least mentioned, if not somehow became the choice of organization to provide the programming. I'm not sure if there's not a process the county ought to follow beyond that to select an organization to do the programming. And I think it's fair for the county to inquire into what the elements of the programming that they're offering are going to be comprised of before the county agrees to go down that pathway. So two concerns: who's the vendor, how did we get them, and what is it that the vendor is actually offering? And then the last comment I'd like to make has to do with, as everybody here knows, judges make bond and bail decisions. What has changed in the recent past, and by that I would say in the last couple of years, the court rule language hasn't changed, but the interpretation that's being given to the language of the court rule is what has changed. Prosecutors don't set bail. We argue for bail in appropriate cases, and in the appropriate cases, even with the program, we will argue against supported release when it's warranted by either criminal history, failure to appear history, or the types of factors that we argue for or against bail as it currently exists. I don't know if that leads to more questions or if it answers any, but those are kind of my thoughts.
Okay, thank you very much. Before we go to Mr. Charbonneau, I just want to make sure we haven't put the RFP out yet, have we?
No, we've got.
So there's no vendor chosen at this point in time. The request for proposals will be going out, but Larry, we can make sure that you can take a look at that. I mean, I would assume all the stakeholders will be looking at that request for proposal before it goes out to provide input on that. Judge Maurer, and then we're going to go to Mr. Charbonneau because we're extending our time quite a bit, so we need to kind of wrap this up.
And I'll be brief. So I think that Prosecutor Haskell brings up some interesting points. And I think that one, it's important to note that the presumption of innocence comes from the Constitution through further case law as interpreted by the U.S. Supreme Court. And that's the reason why judges are not allowed to order from the bench pre-trial sentencing requirements like treatment. So we could not order pre-trial for them to go get alcohol, drug treatment or mental health treatment. That really is the reason why it must be voluntary. We will recommend an order that they go to meet with this pretrial release officer, but it would, potentially violate the way that the due process clause has been interpreted by, I suppose, the highest court in our country, for us to then get reports back and make some kind of sanctions or revoke OR based on their willingness to comply with voluntary programming. The component of this that's voluntary is voluntary because we don't have a mechanism because of constitutional and court rules to force them to do it. But what we know is that there is a certain population of folks who are challenged with coming to court and making their court dates, and that's really what we're trying to address here. The court rule is correct in terms of and I'm looking at CRLJ 3.2. The presumption is unless it's a capital offense, shall be at a preliminary appearance or reappearance. Ordered release on the accused personal recognizance, so OR, pending trial, unless, and then it lists the 3 requirements. So, and again, by case law, not simply by looking at the court rule, but by case law, a violent crime, this state of Washington, for example, has refused to recognize even DUIs as violent crimes. So there is that tension between what a judge can hold someone on under whatever or how violent crimes have been defined. Now we have other statutes in which we can impose pretrial release conditions or hold those folks. And the other thing I think it's important to remember is that the judges will be informed whether or not the person made the initial contact as required by the court to the pretrial release entity, whether or not they're coming to court, and whether or not they've committed new crimes. And the court always has at their disposal the ability to revoke OR and to impose bond. So even if they're missing court, they don't follow up on these voluntary programs and they're missing court, the court can revoke that OR and impose bond.
Thank you. I want to make sure we have a chance to hear from Mr. Charbonneau and from risk management. So from Steve.
Thank you. Well, I think Judge Maurer summed it up pretty well from the defense perspective. I have the same interpretation of CRR 3.2 as she does. My thought on it is simply it's another option for a judge, right? So yes, there's OR, yes, there's bond, and it's somewhere in the middle. But, and Judge, correct me if I'm wrong, but I believe that some of these candidates that the judge or the courts would consider are going to possibly be OR'd anyway. So if you don't have supported release, I believe the courts are probably going to say, well, presumption of release under the CRR 3.2. Okay, well, we don't have programs, but here you go, you're released back into the community. So wouldn't it be better in my perspective or my mind to at least have options for them? Are all of them going to comply and do what they're supposed to do on treatment? No, of course not, right? That's not going to happen. But the ones that do, you're going to, in my opinion, reduce recidivism. You're going to reduce FTAs. You may get them the housing or the treatment or whatever they need pre-trial, may help resolve their cases, may help them not come back at all. Other than that, that was all I had, unless anybody has any questions. Thank you.
Yeah, I've had a lot of discussions with the sheriff and with Mike and Judge Maurer and Larry, especially. Initially, when the program crossed my plate, I had a lot of concerns. I had a lot of concerns about county liability. And, we like to throw the word risk out quite a bit, right? But risk is different from potential liability for the county. There's risk in everything we do, some good, some bad. I agree with Colin that this certainly provides a third option. Are the statistics going to show, and I think the statistics even from New York are kind of swayed based on what the data is they're collecting and trying, to put it in these different buckets, and it didn't really fit that well. I think really what we need to look at is, it would be nice to know how many people go through the voluntary program. And it's important to recognize that too. There's no conditions here, right? It's a voluntary program that these folks can go to get the services they need. I agree. A lot of them aren't going to complete the whole thing. Some might get a little bit of it, but anything is better than nothing. So as far as county liability, I don't see any because it's pretrial. There's no condition set. As far as risk, there's always risk, right? And some of these folks are going to reoffend.
Because some of them might get the services they need and reduce the programs that we're looking to reduce.
And so how is your risk with it being a third party that is going to be doing this?
Most third-party contracts, again, I'm always involved in the contracts to make sure that appropriate risk transfer tools are in place. Quite honestly, I don't see a whole lot of risk for a third party either, because it is a voluntary program and they're there to provide the services as long as they are qualified and certified to do that. Then I don't see a whole lot of risk from them either.
Okay.
A bigger concern I had, quite honestly, on the program is how the money was going to flow from MacArthur through the commissioners or through the district court. And again, it's my belief always that at the end of the day, the legislative authority carries the liability exposure. So we have to make sure that that funding mechanism of how the funds flow from MacArthur to its final destination is set up appropriately.
Because I just thought initially that was with it being a third party, and that's why we were looking at pretrial services to be doing this was part of the risk that you weren't comfortable with.
And it was initially with some of my initial discussions with Larry, because we're, again, also talking about this risk tool, which we've come to learn hasn't worked out to be what it was designed to be. I know Mr. Bingham from the city really talked about a lot of studies that came out and found out that the risk tool, people were getting away from risk tools because it wasn't providing the results they wanted. Not that they weren't accurate and they weren't true, but they just, again, wanted to put them in a certain bucket and it wasn't fitting, so they wanted to go away from it.
Okay, good, thank you. Okay.
So moving forward, and just a commitment from the stakeholders to move forward, and then also to continue to recraft the RFP and get that out to the stakeholders so they can review it. And so that's what I'm looking for. Just before I spend a lot of time and energy developing something, I want to make sure that we have that congruence and support of all the stakeholders, including district court and the prosecutors. And then I will journey forward.
Okay.
So having that support, I guess I move forward.
So I think we just need a head nod at this point, because then it'll be going out for a request for proposal and come back before the commissioners at that
Correct,
point.
yeah.
So I guess I would look at the three commissioners first, or maybe look at the stakeholders, because we had stakeholders that wanted to, make sure that, I think for me as a commissioner, I want to make sure the stakeholders are all in alignment before I choose to, put it forward out there. So I'm going to look at Larry and Judge Maurer and see if you guys are in favor of moving forward with this.
I'm fine with it, subject to the caveats that have been mentioned, and especially, not especially, but including the ones that Steve just made, having to do with the flow of the money and the post MacArthur sustainability. That was another important factor, but I would be a yes.
Okay.
The judges have voted unanimously to support the programming as envisioned by the most recent diagram there that Mr. Sparber presented.
Okay, and the new charter has been out to everybody, right?
I've not sent a new charter out.
Okay.
Yeah.
So
So
you-
the charter of the program has been revised too. I will send that along with my draft of the RFP to everyone. So you can
Okay.
review it.
very good.
Yeah, I'm in favor. Thank you.
Steve, great. Okay, so then the commissioners.
Well, I guess I'll jump in here. I was optimistic about the previous program that had a lot of concerns. And the fact that it wasn't collaborative in terms of its approach and representing the interest and concerns of all the parties gave me great heartburn and stuff. And so I just want to say thank you to Ozzy for bringing everybody together and charting a path that allows us to at least try this. I mean, it is a pilot, and we've launched a number of pilots to try and make the system better. Some have been successful. a lot have not. And we continue to be challenged by, a jail that's overpopulated and stuff. And so I'm more than happy to support Ozzy and Sparber and the judge and the prosecutor and public defender in test piloting this program and seeing if we can make it work for Spokane. I know, as Commissioner Kearns has indicated, attempts at this in other communities have failed miserably. In fact, one story I read, the state attorney general for the state of New York was so frustrated with the increase in crime in New York City that he actually interjected himself to try and change the direction of some of the programs they were doing. So I clearly do not want Spokane to be in that situation. So, this is a pilot. Let's try it. It's worthy of investing some time and energy in to see if it can produce the outcomes we want. I think we all want an equitable system. It's just, how do we get there and stuff? So I'm in favor, and I just want to say thank you to Ozzy and all the stakeholders, Larry and Judge and the courts and everybody, Sparber and stuff, for coming together and trying to find a path forward. So appreciate your efforts and thank you.
Commissioner Kearns?
I agree with everything Commissioner French just said there. But yeah, no, I want to thank our team for getting together, working through this. Thank you for addressing my concerns that I brought forward today. Thank you for clearing up some of those question marks that I had. And Steve, thank you for addressing the liability question, because I know that was one thing that was a sticking point for me a couple months ago when this first came in front of us, was what actually is that level of risk or level of liability for the taxpayers that could be created. And if you feel that it's that we can mitigate that, or it's low enough, I appreciate that, and I'll support us moving forward from here.
Great, thank you. And I will echo what's been said. I think, knowing that Steve is much more comfortable now. And I think all the stakeholders are all agreeing to this, because I think we didn't have that consensus before. So I appreciate the work of, Mike as well and the sheriff to really make this come back together, because I think it is important to have that option. And to try. Again, it's a pilot. And so we just want to be, being the best stewards we can and helping our community be better. So thank you all. So
Thank you.
I think you've got all the stakeholders and all the commissioners in favor.
All right, thank you.
Thank you all for being here. Sorry we're over time, but it was an important conversation.
Thank you.
Okay. Next up, we have Doug and Kirk Chambers have come back to talk to us. Where do you want? We're still a little ways. We've got one more before you. Appreciate you guys staying along with us and being here. So
Very interesting. Great. A lot of good work being done in a lot of areas. So we appreciate the opportunity to come back and visit. You might recall Kurt had a fantastic presentation last week, but there were some very good concerns expressed over the 5-year lease option to purchase in regard to recent legislation that was pursued that would eliminate any future purchases of non-electric type power equipment. And so Kurt went back and he looked into more of a purchase option and in fact found, I think, a perfect fit that will actually only add, I think, $2,000 a year during the 5-year period and ultimately save us money. And I'm taking all of his thunder, but we've updated a couple slides to show the difference in cost. So Ron might be able to pull that up. I did bring some copies too, just in case, where the numbers, it's always fun when the numbers can just speak for themselves. It's like so Kurt, why don't you jump in and explain what you found?
Okay, so thanks Doug, and thanks for having us back. And going back to the company that's offering financing, asking, is there a way we can be contractually bound to purchase after a lease? In that particular lease, it was no. He proposed another option called a municipal lease purchase. Next slide. As Doug let us know, the annual increase is only $2,000, but there's no balloon payment at the end, so it works more like financing. So in the long run, it could save, within 5 years, up to $100,000 on this. And it gets us around any question as to whether we will be allowed to purchase because of the legislation that may be presented. So the equipment after the first 5-year term would be the ownership of the county, or an added $2,000 annually. See that in this slide, and it's termed a municipal lease purchase. It's still considered a lease, but it works like a finance program.
Okay, and so then, of course, you're saving some because there's no balloon payment at the end. We're just paying a little more upfront.
Correct. The balloon payment, they couldn't, which was a mystical thing too. It was 17 to 25%. So that's gone. It actually lowers cost.
Okay.
overall.
And then, so then the 5-year term is what you feel the value of the equipment is.
Yeah, I think that it makes the most sense for depreciation to go 5-year term. And then we will still continue the plan and own it for 5 additional years following the purchase. And at that time, we would surplus or trade in. And then at the end of this 5-year term, we would initiate another 5-year lease with a different set of equipment in order to complete our needs. of all our own equipment.
5-year lease purchase.
Yes.
Which can be reevaluated at that point in
Right,
time. too,
yes,
so.
yes,
Yeah.
at some point that equipment may be available, it may be desirable.
Yeah, absolutely.
Mr. French.
So the next slide just shows some of the savings on the purchase side, which the purchase side included that balloon payment. I slid some equipment around to get a more balanced annual dollar, and it actually fit better with our 20-year plan. So those on the bottom, the orange ones are the updated years where there was I moved stuff around, and those are also the years that the lease payments were coming due. So, and then for a further picture, I just updated all of the changes just to be 100% transparent. That concludes our updates. I think that hopefully answered the question that was presented last week.
Any questions or comments? Mr. French.
So nice work. And my question is not meant to challenge anything that you've done. But I'm really thinking about the legislature and what it could do to us. And so if you knew that in 5 years, you would not have the opportunity to lease your second round of equipment, and you only had one shot at it, is there anything you would do differently than what you proposed? What I'm trying to get to is that the legislature takes that away from us. What can we do? What would we do today, knowing that that's a possibility? Or is what we're doing today the best we can do because it's all we can afford to do?
I think it's probably our best option at this point, given technology is changing rapidly in that industry. And as Doug noted, some of the advancements may be something that we want to pursue. Yeah, I think there's a lot of crystal ball there.
Yeah.
Another option would be to potentially look at that next 5-year bundle of equipment and look at putting it in this and maybe extending terms. I don't know how long the finance company would be willing to offer terms and or what the financial picture would look like. But if we could afford it and we didn't like the way that things were heading, possibly that would be our better option.
Okay.
But I feel like right now, this is, with confidence, I'm saying this is probably
Okay.
a very, very solid route.
Okay, thank you.
Any comments, Josh? No.
And the only other thing I can think of we might want to consider is a double tandem trailer with one part of it pulling a generator and the other part of it pulling coal to feed into the generator. But that's just an idea.
Some extension cords.
And it's long extension cords. I'm really into long extension cords. Obviously, that's a joke.
Scott?
Great job, Curtin and Doug. Just a quick little recap of the financials, if I'm following correctly, for $2,000 more a year for 5 years, quick math is $10,000. The year 5 or 6, when the purchase would have had to occur in the first year, we're saving $30,000. In the next year, we're saving $80,000. So you can see the returns and the changes that you've done on the program are significant, and there's a less cash out over time. So great job on that. And for the commissioners, what you're asking of them is support for a program. And each year, when we would look to lease equipment, there will be an action by the board to approve that lease. And we will continue to be informed on what's changing in the equipment marketplace, what's available, if this is still makes the most sense to commit to another 5-year lease, another 5-year lease. Accurate? Absolutely. Okay. So I think that kind of goes back to Commissioner, your question around how do we pivot perhaps in the middle of this. We've got an ability as we continue to learn what programs are available for us.
Yep.
So one question I have is just on the financing side of it, what our rate is. Do we know what the kind of the rate is, and did we look at the treasurer's office for this? I mean, I guess we're looking to lease, but now that we're doing this municipal purchase, which great job. So I don't want to get too far, but is this something that we could have gone to the treasurer's office for or not? Or it's better just to do it through this financing company?
My sense is, I'd want to see if Gary could weigh in. My sense is this is it's a lease program offered directly from a third party who is an equipment man, who deals with equipment themselves and is extending terms to us, right? So otherwise we'd have to purchase it outright and do some sort of loan back through the treasurer's office to do that. But that's just my sense. I want to ask the team and see if Gary has good weigh in too.
Yeah, I think Scott is right on it. It's just like similar to leasing a copier or anything else. It's that type of equipment situation where if this was a long-term financing arrangement, we would definitely look at exploring possibilities through the treasurer. But in this particular case, because it's wrapped up with the equipment, and they've demonstrated a very good plan that they've put forth as it relates to future years and what we can do and how flexible we can be in the future. I think it strikes a really good midpoint to give us the maximum flexibility and best operating stance. So I congratulate them on their program and the way they've been able to save us money by restructuring it as a capital purchase too.
The rate that, and it's through Huntington National Bank, is who Toro works with. The rate was 4.89% guaranteed for 90 days from last week. So
Is it a variable or fixed rate?
it's a fixed rate.
Yeah. Great. Thank you. No, I know you've put a lot of effort into it, so really appreciate it and appreciate you going back and looking and questions that came forward and then we get to save more money. So
Yeah.
that's a good thing.
Yeah.
And I think, yes, having that plan for replacement and all of that moving forward is really important. So great job on putting that together and using the dollars that we've gained on proceeds to do that and do it well for parks.
Enormous, so we really appreciate you considering this opportunity.
So then I'll come before us a lease agreement that will be on the 2 o'clock consent agenda in the future, correct?
Okay, we will work to make that happen.
Okay.
Thank you very much.
Thank you.
Really appreciate your support.
Okay, Deb, I'm trying to keep moving along here.
Yep,
Thank
I'll
you
make
very
it as
much.
quick as I can. I'm here today just to give you a brief update, very brief, on the regional solid waste system. And we hit a milestone since we took over the system in 2014. We now have all of our interlocal agreements have been up, and we are extending them. So we're making amendments with all of our member jurisdictions to extend their interlocal agreement another 5 years to stay in the system. And on top of that, we also have a new interlocal agreement that we have created with Cheney. So Cheney is now joining the regional system. So we're working our way to get a more complete county with our garbage system. So this is just a little handout that I gave the member jurisdictions, show them the benefits of being part of our system. You should see the documents come across your desk this week, I believe. And that's where we are. So also, I just wanted to segue, I know Gina has a video, and if you guys still have time for it, that's fine. One of the benefits of the regional system is the outreach and education for everyone. And we actually have it's called a revenue sharing agreement with Waste Management for unincorporated areas of Spokane County to use some of the commodity value from recycling that they will take and create some educational and outreach materials. And it benefits the whole county, even though it's strictly waste management, because the message is the same. And so we have a little video that was created with Waste Management in conjunction with Spokane County.
Yes, we want to see it. It's like, I know it's a big deal for you guys in Waste Management, or WM, now they're calling themselves, to put it together. So, and I think it's a great collaboration, shows that, so.
It took us three iterations to make sure we got it right and made it more regional instead of waste management focused. So they agreed to it.
Okay.
And I'll send Josh a link.
Okay, so they won't be able to see it on Zoom.
No, just it's on his computer, but
Okay,
Josh should be able to hear it.
and then we'll have the link when we post the video, we can put the link to it.
It is a 6-minute
yeah,
video,
comments.
so get your popcorn out.
And you trashed the first 2 copies.
Mr. French.
So just by way of an update, I know that Deb has been part of these conversations as well. You know, for a long time, we've been pursuing the transload rail facility up in the West Plains. Well, one of the reasons is because it provides a shorter haul for the waste, the ash out of the waste energy plant, which is currently transported to the valley. It can now be transported, well, hopefully it will be transported to the West Plains transload facility, which is under construction right now and should be open this fall. So a couple of weeks ago, Scott Simmons and I met with Johnny Perkins and continue to be in conversation with Republic about and BNSF about how to move this forward. This could reduce cost for all of our taxpayers in the system. And so that is moving forward as well. So just thanks to Deb and all of her involvement in terms of trying to make the system more efficient and more effective for us. And it's just another step in the process.
Yeah, great.
Thank you. And you guys should all see my face in the next few months. I'll be knocking on your door because we have a lot of ideas to make our system more customer driven and more efficient, save some money. So we're putting some ideas together to bring forward.
No, I think it's great. I think you're showing the innovation and the education and trying to educate the community on doing it right. So it does make it more efficient for you guys too. So thank you for all your hard work. Appreciate
Thank you
it.
for your time.
Deb, are we going to be promoting that on our website, Facebook, that sort of thing?
Yes.
Excellent.
Yep.
Yeah, just
Good video.
work with Sharon, because yeah, the more that we can get it out there, the better.
We'll do that.
I learned things when I was watching it, so.
I always learn things every day.
My biggest fear is they'll start recycling husbands.
I'm not ready for that yet.
I think my wife is.
Okay, thank you very much.
Thank you. Okay, that leads us to Jeff, you and Arian.
Marion's on video today. She got a cold over the weekend and didn't want to share it. So I'm
We
working
appreciate that,
along.
Arian.
So this is, I'll cover mostly a reminder of last week when we briefed you on the addressing drinking water transmission and distribution RFP applications. And we presented the board with a short list that was Whitworth, Irwin, and Trentwood. And that's just where the natural break was in the scoring process. Those all scored at above 90. Everything else was mid-70s and lower. The board gave us the head nod to move forward. And then the third bullet point on just the agenda also is addressed towards there. You'll see our resolution tomorrow, increasing your appropriation into the 5.11 category by an additional 105,100. You started with 4 million. That will take it to 4,105,100, which allows you to fully fund those 3 requests that made it through the committee. And the second bullet point is the addressing educational disparities, academic, social, and emotional services. You'll recall there was only one application that was received. That was Inovia and their Launch Northwest regional view of this. It did pass, I guess, since we're not comparing. So you'll also see tomorrow, and the resolutions tomorrow are both affirming that you're accepting these, and then it's also moving forward with the grants office to start the contract phase. So there will be, until the contracts are in place, specifically saying what can and cannot be reimbursed with ARP funds, no reimbursements will happen. So we're a little ways out from actual reimbursements happening, but this does affirm to these 3 water groups in Inovia that they have received the funds.
Okay, they've met the.
They met the threshold to receive the funds.
Yes.
Yeah, so bullet point 2 says that the resolution is to approve the contract.
Probably better choice of wording would be to approve the contracting phase.
Okay.
The contracts have not even begun yet because the board hasn't
Which is on the-
actually done that. Yeah, so that's forward
First one
choice
as
on my
well.
part.
Yes, that's on the first one as well.
Correct.
So-
So that's true of the first bullet point also. It's approving the contracting phase to begin with these 4 entities.
And for clarity, Commissioner, the item on your agenda tomorrow is in the matter of selecting and approving the firm for the ARP for each of those two categories.
Arian has a few additional ARP.
Good morning, Commissioners. Just to add a little clarification on that, what we have decided to do as precedents when we bring the selected firms or firm to you is to include, based on purchasing recommendation, the authorization to go directly into contracting phase based on the cost proposal. This allows us to do kind of a two-touch at that contracting element versus coming back around again. So that's why that verbiage is the way it is. The other item that will be on your consent agenda tomorrow is that additional amendment for increasing the allocation to the drinking water category by approximately 105,000 to allow for the awarding of all three firms on the short list. It also has one minor amendment that changes our 2020 revenue replacement category, as the Treasurer's Office did revise the calculation. So we were able to increase our amount by approximately 250,000. So that is what that amendment is on your consent agenda tomorrow. Also, we are in the final stages of approving, signing the contract with CLA for the application portal. They are expected to return their signed copy today, for which then that will be before the board for final execution. One question I have is, since the resolution that accepted CLA as the preferred firm also had this contracting component in it, would the board be amenable to having the chair sign that final copy for execution on behalf of the board, or would you like it to be signed by all three in session?
I'm indifferent. Doesn't matter to me.
We are hoping to have it signed in the next couple of days, so we can gain probably 3 days of work if we didn't wait until next week for a board motion.
Yeah, I'm fine. Mary's got nice handwriting.
Thank you. I'll just want to make a motion. Do we need a motion to sign in other than an open public meeting by the chair? Marcus shaking his head yes.
Okay, Madam Chair, I would move that we authorize the chair to sign contract with
CLA, Clifton Larson Allen.
them and other than an open public meeting.
I will second the motion.
Okay, I have a motion and a second. All those in favor, please signify by saying aye.
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 Motion passes unanimously.
Thank you, Commissioners. This will allow us to stay on track for.
Arian, just second, Commissioner French.
Oh, if she finished her statement, then I've got a follow-up question for Arian and Jeff, which is kind of, I didn't prep you for this question, so I apologize, but I know you're agile.
My apologies. I can't see the window very clearly, so I apologize. We are still on track for finishing the onboarding concurrent with the next set of RFP releases in mid-May. So I just wanted to let you know that so far that's still on track. Commissioner?
So I apologize for not giving you a heads up that I was going to raise this issue this morning, before this morning. So, but I think it's timely. And so there has been, especially last week, a lot of conversation in the community from the Spokane Alliance, making accusations about things that we are or are not doing, or failure to respond to them, and which is just factually inaccurate. And I know that both you, Jeff, and Arian have made great strides, as well as Ron and Steve and Brenda, in terms of trying to outreach and educate as to the process that we're involved in with regard to ARP funding. Could you please, just for the record, inform us as to what efforts you've taken to date And what the response has been to complying with the regulations that we're all forced to comply with from Spokane Alliance.
So about a month ago, Erin and I had a Zoom conversation. There were about a couple dozen people on the Zoom, I would guess. It was a friendly conversation with us, and we laid out, just the process, the categories, how it all worked. They let us know they're going to follow up with your offices, which they did. And then probably it was prior to the 14th when I left on vacation. So I'd say early April, Erin and I also had a conversation with Empire Health Foundation, brought together a broad group of stakeholders, which there was a lot of overlap between Spokane Alliance and the Empire Health Group. That was a good conversation, not quite as friendly maybe. They just directly asked the commissioners to allow them to decide how to spend the $101 million. We let them know we didn't think that would happen, and the way Congress set up the rules. We also let them know that the addressing educational disparities was, I believe it was actually open at that time, or was going to open up. And Arian multiple times, at least once or twice, I mentioned, we encourage them that there is a category that would address a lot of the needs and concerns that they were bringing forward. Based on our application closing, or our portal closing with only one application, the decision was made not to apply for those funds. We also let them know, like, the affordable housing category would be coming out. There'd be other opportunities. At this point, the Inovia Foundation, Launch Northwest, since they will be receiving the funding, a lot of the work they are doing will be sub-granting out to other nonprofits in the community after they do their needs and gap analysis on what they see to get to the end goals of their objects. And so we have also let these groups know that they could talk with Inovia and see where they might fit into those broader plans. Anything to add, Arian?
No, I think that's a really good overview of our conversations to date. I think the one other thing that we did have some just touch point conversations with the Spokane Alliance, and I did do a follow-up request to our grants office, is understanding how they felt that their allocation from CARES funding was received in the community, just as a follow-up for ongoing considerations, because ARP funding is meant for resiliency versus acute reaction, which was different in the CARES world. So I think that's another thing that will be helpful for the board in their consideration going forward, is how much or how their final reports came in from the money that they received on behalf of the county by the commissioners in years prior.
It was a $3 million grant from the county with CARES funding. We've not heard back yet on from Spokane Alliance. We're trying to get documents from our grants office on how that funding was used, and hopefully some positive outcomes.
And it was my understanding, we did the $3 million of CARES dollars to them for childcare. And then, but, they weren't able to spend it all in the amount of time. And then with the extension, they were able to then, use it into the next year. So it gave them a lot more time to use that. And, that would have just ended at the end of 21, correct?
Yes.
Actually, if they had a contract in 21 and had leftover funds, it's actually the end of this year that they would have to finalize the reimbursement reporting. So once again, we'll know more from the grants office when we see where their recipient and sub-reporting reports are, if there is a current balance remaining.
So I'd like to ask Ron if you'd like to weigh in on this in terms of your interaction with them or not.
Steve and I had a meeting with some representatives of Spokane Alliance, and probably the best word I would describe would be aggressive.
So that's why we have these folks here, is because they're very professional, and what was, as I understand it, an extremely contentious and accusatory environment with regard to the board and our decision-making, especially to comply with federal requirements. It was not as gracious as our professionals here have said on the record. We've been accused of not having care for childcare industries, despite the fact that we contributed $3 million to help them get through the COVID environment. And despite the fact that we have federal regulations and we've defined a process for them, they don't like the process and it is now our fault. I just think that it is this dialogue out there that's not based in fact is very disappointing at best. And so I just want to put that on the record that we're all working to get through this together. But accusations and character assassination and stuff is inappropriate for this process. And I just want to applaud the professionalism of our staff for getting through this.
Yeah, and we're not seeing any other organization, municipality, county, just giving their funds or turning their ARP dollars over to nonprofits because we can't.
No.
There's a federal regulations that we have to follow. We are the ones that, as a former auditor of single audit federal dollars, we're the ones that are on the hook for that. And we need to make sure that those funds are being spent appropriately. And as we do these contracts that, ensuring that those contracts meet requirements of the feds. So it is our obligation to our citizens, because if we don't do it correctly, or if we turn that money over to somebody else and they don't do it correctly, we're the ones that are on the hook to pay it back. So that is why it's very important that we go through this process and everyone is being very professional. We want to know what the needs are out there. And so we've been asking people to, go into the portal, let us know what the needs are. That is not means you're going to get funded, but that means that we're going to get aware to know what the community needs are for the ARP dollars and ensure that those dollars would be appropriate in meeting the federal guidelines. And as we know, we just got another set of 50 pages of federal guidelines that came out last week. So it continues to change, which is why we've been very purposeful and paying attention as we're looking to put funds out. We don't get our second round of funding until middle of this, mid-May or June.
We're expecting end of May, but nothing's confirmed.
Yeah, so we don't even have all the funds, and so we're just being very intentional. So I concur with Commissioner French. Okay.
I had one other item as part of the ARP update, just for awareness. You will have on your consent agenda next week just an artifact for the board to recognize the formation of a broadband action team with the WSU Extension and the State Broadband Office. And this team will be composed of local stakeholders, with Jeff and I as the co-facilitators among both community and stakeholder access to kind of govern our holistic approach as broadband funding and efforts come forward. So I just wanted to give you a heads up that that document and resolution will be before you next week.
Thank you. Anything else? Okay, so that's going to take us to a presentation from Ashley Cameron and Josh Grove.
Hello, commissioners. Thanks for having us here today. We are very excited to be here and present yet another contract that has been tentatively negotiated. This contract was negotiated over a very quick period of time, and both groups were very actively engaged in positive participation on both sides of the table. So that was very exciting to see. All proposals, TAs, and notes can be found on our SpokaneCounty.org labor tile. So if there's any questions around any of the discussion, it is out there and available for review. But I do have Josh here with us today to present the high-level details of the tentative contract at this time. So Josh, go ahead and take it away.
Thank you, Ashley. Good morning, commissioners. We briefly touched on this last time we met when Ashley and I presented the Council 2 negotiations update, but I wanted to bring it back to you to go into further detail. So once again, this is a contract in a union that covers approximately 8 employees of our mental health professionals and diversion case managers in detention services. This agreement had expired in 2020, so it was open. But after 3 sessions, we were able to come to an agreement on April 21st on a brand new 3.5-year contract. The union members voted in favor of the agreement on April 22nd, and the yearly cost increase for this contract is approximately $40,000 in year 1, $58,800 in year 2, $51,000 in year 3, and for half a year, it's approximately $24,000. And the reason for that half year is to get this contract off cycle. Most of our contracts expired all at the same time, and to get some of these contracts that aren't tied to each other off cycle, we've been building in an extra half year one way or the other. Next slide. And so some of the major changes in this agreement is that we negotiated new health insurance language that provided us with the flexibility to make changes to our current plans and introduce new plans if we so choose during the term of this contract, but we still were able to provide adequate coverage requirements for each of the bargaining groups, and this group is no different. We were able to get language in that would allow us to move to a lag pay system, normal payroll system during the term of this agreement. Once again, we're able to move this agreement off of the typical cycle that we have seen with all the agreements expiring all at the same time. We were able to get new grievance liability language. So if an employee or the union knows that there's an issue, this language would mandate that, or basically encourage the unions and employees to file a grievance as soon as they know it. Before, we did not have any type of language that capped our liability, and so unions and employees could sit on grievances if they so choose. But now we're only required to pay back 180 days for these type of grievances. Does not include arbitrations for disciplinary reasons. Many areas of cleanup within the contract. Previously, this group was known as 492N and 492 Mental Health. With no longer having nurses, it has just been retitled 492M and just other areas of cleanup within the contract. This group, because it is within corrections, shares very many similarities to the corrections contracts. And one other issue that we kind of standardized within corrections is move away from longevity to a service enhancement pay that is only in effect for those employees who work 7 years or longer. We added the Juneteenth holiday into this agreement. This group is eligible to or was part of the classification study, and so they adopted it with COLAs of 3% in 2022, 3% in 2023, 3% in 2024, an additional 1.5% in 2025 to get us through half a year, knowing that we will begin negotiations sometime in April or May of 2025 for the remainder of 2025. And then in addition, we also provide them one-time lump sum payment for ratifying the contract on the first try. And it was done, and that was in total of $500. And so all in all, as Ashley pointed out, this was a good group to work with. They were readily and willing to come to the table to get an agreement as quickly as possible. And we were able to do that, and we appreciate it. So do the commissioners have any questions?
Any questions for Josh or comments? No, I would just say great job in getting us to the, negotiating the contract. So thank you very much. We really appreciate that. And
Thank you, Commissioner.
Commissioner Kearns? You're good. Okay.
Great, thank you, commissioners. And just so you're aware, this will be in your consent agenda for next week. So in the event you do have any questions over the course of this week, please feel free to reach out to Josh or myself. But you will see the actual resolution for adoption next week in your consent agendas. Thank you.
Okay, very good. Thank you.
Thank you.
That is going to take us to Gary Petrovich, and we have some people joining us.
Thank you, Commissioner. We have Jim Amacio and Roy Cogan here with us today. And I assume Mark is on the screen, Mark McLean.
Yeah.
And so as a team, we worked on putting together the agreement with Pacifica Law Group for bond counsel. And a lot of the agreement was structured on the basis of the prior agreement that we had with Kutak Rock and Mr. Cogan. So the one things that we wanted to emphasize is that in the agreement, they'll provide up to 10 free hours of consulting, and they're each month. And it won't accumulate. So if they don't, we don't use 10 hours, it won't move forward to the next month. And they will be working primarily on our bonding work, and any of their costs incurred with regard to those bonds would be part of the cost of those bonds. Now, if they're going to be working on something outside of that arena, they also have a proposed fee schedule that we've also attached in the agreement. Ron, do you want to call the agreement up, and each of you should have had a copy of the agreement sent to you on Friday, Mr. Amacio. And there's not a lot that I have any concerns with. I think everyone's pretty much gone over it and is pretty happy with it. We're hoping that if the board is acquiescent to that, we would like to send this off to Pacifica Law this morning or this afternoon. And then we have it queued up for a signature by the board on their consent agenda on next Tuesday, the 10th.
Madam Chair, pardon me, Commissioner French.
Well, I just wanted to ask if this had the provisions that we talked about with regard to SIA and allowing for separate bond counsel, if that's the direction they wanted to go in.
It doesn't. This appoints the city or Pacifica as the county's bond counsel. And I thought the arrangement was that since you've gone through a county selection process, that if SIA was uncomfortable with their airport experience, that SIA would retain their own counsel to the board. And that if they do so, that would be, and I think they're going to do so, that would be a cost the airport board would pay and they get reimbursed as a project cost. And one of the concerns that we had, and I've had a discussion with Pacific about this, is if you have two bond firms working on one project, whose documents do you use? And I talked to Deanna Gregory last week, and she is amenable to starting with the QTAC documents. I think that would be the best place to start. So I think everything is in place to go forward. The other thing on the 10 hours per month non-cumulative, Pacific is in charge of monitoring those hours. So if they go beyond that without county consent, they don't get paid.
The other factor, board members, that we want to make clear is the board did go through a selection process with regard to bond counsel. And in the past, we've used Mr. Cogan's firm, but now that Mr. Cogan has retired from that firm, we went through a selection process. And as the board is aware, the selection team recommended to the Board of County Commissioners that the board employ Pacifica Law Group as your bond counsel. The way the agreement is structured, it's really structured for a 2-year window, but the board has the right to terminate it for any reason whatsoever on 30 days notice. There's 2 separate fees in the document. The first fee deals with bond counsel services. And we have a schedule in the particular agreement that articulates what the base fee is, depending upon the size of the issuance. And we've had Mr. Cogan review this because he is most familiar with what the fee should be. And I think Mr. Petrovich and Mr. Cogan and myself are of the view that these fees are appropriate fees depending upon the size of the bond issue. In addition to that, the agreement is structured so that we can use Pacifica for other kinds of legal services from time to time that we might need that are somewhat or not related to the bond issuance. And there's a fee arrangement in there with respect to those particular services. This agreement is broad enough to include bond issuances like for the small arms range and for the training facility that we will be issuing, ULIDs and RIDs in the event we go down that road. From time to time, there are tax increment financing districts that are prepared. And what we would expect in that regard is we would ask, the county would tell the developer who wants to form a tax increment financing, you have to use our bond counsel, Pacifica, and you will pay those fees, but Pacifica will work with the county. And then the developer can get reimbursement out of the revenues from the TIF to pay them back eventually. So we believe the way this agreement is drafted, that it covers bond counsel services, ULID, RID, TIF, and also additional services that we may need from time to time. So we are recommending that the board place this on next Tuesday's agenda. We have the resolution and the agreement all ready to go. And of course, we're more than willing to answer any questions that you may have.
You know, with respect to TIFs, and there are 2 pending or possible TIFs pending to my knowledge. One is a recent one with Mr. Edwards and Mr. Welch for about $700,000. The other is the Kaiser TIF out north. And what we did, and we were county bond counsel for each TIF, we would prepare an engagement letter, send it to the developer. And that engagement letter would say, Spokane County is our client. We will do this and you will pay for our fees. And the reason we did it that way is we had a couple of experiences where we spent a ton of time, the TIF did not go forward. So we thought, no, the county should not be at any economic risk. So we would envision the same arrangement with Pacific and a developer.
And one of the reasons why we like to use bond counsel is in some instances, the county may issue bond issuances in conjunction with capital costs under a TIF. And because we may issue bonds, we've got to ensure that bond counsel has looked over the formation documents so they feel comfortable in giving a bond opinion that we can actually issue bonds, regardless of whether the bonds are sold in the public or whether or not they're purchased by the developer. So, and those are the 2 options that we may be looking at.
And then on the flip side, if you don't issue bonds, that engagement letter would let bond counsel get paid because the county would not have bond proceeds coming out. Then the developer would get reimbursed. So again, it was the intent to keep the county's costs at 0, payable only by the developer or from bond proceeds.
I believe the Spokane County has more tax increment financing districts, I think, than any of the county state. My recollection is correct, Mr. Cogan. I think we have maybe 5 at the present time, or we had 6. And
that is correct. And Spokane County did the first one in the state.
Mr. Vanderburgs.
The bonds were sold. There were 10-year bonds. And it worked perfectly that private development came in, the bonds were paid off in full in 7 years. Then the TIF was terminated and the taxes were redistributed as if there was not a TIF.
So would Pacifica be involved with the extension of any existing TIFs that we have, or is that something that we can handle internally? And I'm thinking specifically of the West Monroe Terrace.
At the present time, Commissioner French, legal, Mr. McLean and myself are looking over the documents with respect to the several of the TIF documents themselves. We intend on having those potentially reviewed by Pacifica because we are concerned about the fact that they may want to issue bonds in the future. So in answer to your question, I think in-house legal counsel can prepare some of the initial documents, but we would plan on having them reviewed by Pacifica under the circumstances that Mr. Cogan has reviewed too.
Then with regard to the conversation with SIA and their funding needs, discovered that Mr. Crowder and the airport have already gone well down the road with Kutak Rock and their bond counsel out of Denver. And so there's probably a desire, and I'll know more this week. I think that decision will be made later on this week, but to continue that relationship with that bond counsel because they've already invested so much time and energy in developing the agreements that will help the airport move forward and stuff. So that's why I had the concern with Mr. Cogan that we allow for that kind of expertise to help guide the airport in terms of structuring their bonds.
You know, I do think that Michael Thomas is one of the best airport lawyers in the country. And I think the relationship will be perfect with Michael representing the airport board, using his documents, which Pacifica will comment on, and then Pacifica will give the bond opinion. So the airport board gets the expertise of if Larry's board agrees to it, that they desire.
Okay, I guess I'm just hearing this for the first time,
Yeah,
so trying to think through, because we have chosen to move forward with Pacifica as our bond counsel, not wanting to set a precedence of having other entities choose the bond counsel for us. And so so I guess I just want to clarify the relationship.
Commissioner, all of the conversations I've had with Mr. Crowder and with Brian Wurst is that the county had gone through a selection process and selected its bond counsel, and that bond counsel would be the county's bond counsel.
So we will be issuing the bonds.
Kutak Rock
Okay.
would represent the airport
Pacifica will be our counsel.
in connection with that bond issue.
Okay, but Pacifica will be the one issuing the bonds for Spokane County.
The bond opinion, yes.
Yes. As we go to sell them and do all that, it's the process goes, but that's Pacifica. So the airport's going to be hiring their own basically independent review.
You know, there'll be three sets of lawyers. There'll be county bond counsel, there'll be counsel to the underwriter, and there'll be airport counsel. And then the three firms will work together on the bond documents. And then Pacifica would most likely do the disclosure documents, because you're going to get that work done by Pacifica at they're charging $15,000 for it, which is very, very low for an official statement. So they would do that drafting. Michael Thomas would do the indenture. And we understand that they're basing the indenture on Salt Lake City as modified by Philadelphia. Both of those cities are like Spokane, where they had no outstanding debt at the time. So it's a long document that will give the airport and the county every flexibility going forward. So the airport has its counsel, county has bond counsel, underwriters has its counsel.
And in the past, who was the underwriting counsel?
It is varied from firm to firm. It depends who the underwriter is. And if the county selects Barclays, its long-standing underwriter, they would probably, my guess, they would use.
No, that's okay. So typically it's been Barclays in the past for us.
Yeah.
As the underwriting counsel.
Yeah, I don't know.
But Madam Chair, the county commissioners will select that attorney. It won't be selected by SIA.
Or the underwriters council will be selected by the underwriter.
Okay, but it depends who it is. If it's Barclay or it's First America or.
Well, yeah, the two firms that have been talked about are Barclays and Bank of America, Merrill Lynch. And that was recommended by Michael Thomas because the guy in Seattle worked on Salt Lake.
Okay, I guess I just want to ensure that it's the county that is the one choosing these. You know,
Underwriting.
Under the underwriting and the underwriting council. I mean, because again, we are the one that are ultimately at risk for all these bonds. I mean, it's not the airport. And so I just want to make sure, again, as we do this, you know, like we did for the PFD, I want to make sure that it's Spokane County that is setting the precedent, again, that it's us at risk.
They're
And
your
so,
bonds.
and it's our bonding capacity that we're using.
They're your bonds.
Yeah.
Your name's on the line. And Mr. Petrovich asked me last week to contact Barclays and ask them to prepare a document which would explain their airport experience. So I've made that request.
Okay. I thought we made that request to Pacifica as well, and they had some, but not, you know, I mean, if the PFD wanted to do it or the airport wants to have their own counsel to review the documents that are being prepared, I mean, I don't have a problem with that. I think it's somewhat of a duplication, but that's a choice that board is making, not us.
You know, it's not that uncommon. For example, when Gonzaga finances, bonds are issued by the higher ed authority, the underwriters have its counsel, and we're Gonzaga's counsel. So you have the three law firms working. So the same sort of arrangement. You're kind of a conduit for the airport, but your name's on the bonds. So.
Madam Chair, I was aware of us going to be using Pacifica and also being used Kutek Rock. And my recommendation is that we have an MOU, and the MOU would make it very clear with regard to this bond issuance, what services Pacifica will be performing and what services Kutek Rock will be performing, because all those costs are going to be paid for out of the bond issuance. And I think it would be a good idea to have an MOU that makes it very clear what we're talking about. It's very clear the airport can hire its own attorney. That's not a question. It's very clear that there are bonds. That's not a question. But what we're talking about here is the airport's attorney, their bond attorney, what they'll be doing and what the county's attorney will be doing, because that's our bond issuance. And so I think Mr. Colgan is saying is certain documents are going to be prepared by Kutek Rock. They're going to be ultimately our documents. And they're going to be reviewed by Pacifica, and Pacifica is going to be preparing certain documents. So I'm wondering, Mr. Colgan, if we shouldn't have an MOU that articulates exactly what's going to happen, so there's no question.
Well, and I guess I want to make sure the attorneys are all in agreement as well.
Understand,
That's how it's all
Chairman.
working.
Yes.
Yeah, what would normally happen is there'll be a kickoff meeting. And at that meeting, tasks will be assigned to different law firms. And that's how it's always been done, Jim. I've never seen an MOU. And, you know, I sort of, MOUs can be effective, but I think it's an understanding. It's not a contract. You know, they're not enforceable. So I think it's better to get the team working together. And we can kind of monitor that to make sure people play well in the sandbox. And having Pacifica agree to use QTEX documents, I think is a big step.
Yeah, I guess that's part of, you know, since you know, we agreed with Pacifica, I want to make sure that we're not upsetting them out of the gate, that we don't feel that they're competent enough to do it, because we're saying by having the contract, we felt that they were competent to do this.
Well, I had that conversation with Deanna Gregory last week. And I said, you know, an issue that we're going to have to face is whose documents do we start with? She volunteered and said, if QTEC has good documents, we'll look at them, but we could certainly start with their documents. And we will review them, of course, to make sure they comply with the state law, because they came from Utah and Pennsylvania. But she really volunteered to say we could do that.
So I may be more comfortable, I guess I'm gonna ask if I have a conversation with Deanna prior to, you know, because I guess I thought I was hearing that you were gonna be sending this contract off to Pacifica today. I'm not comfortable sending this off today until I think think, assure myself that they're comfortable with how the arrangement's gonna be.
I will share her contact information with you.
Just, since, I didn't realize the airport's already gone down, a path. So I just want to make sure that Pacific is not feeling that we don't feel that they have the qualifications to do it.
And Madam Chair, pardon me, go ahead, Chairman.
Well, and so the airport had moved down the road with Kutak Rock and Mr. Thompson before we knew that Roy was going to be retiring. So it wasn't that they were operating outside of the parameters that we were working within. They just, the game changed when Roy announced that he was retiring. So, but they've already invested an awful lot of time and energy with one of the best bond councils in the country with regard to airport. And yes, while Pacifica indicated that they had some airport experience, their breadth of experience wasn't as broad as what we need for SIA. So so there was conversations about, well, how do we get the best and the brightest to make sure that the airport is protected? Because I think all of us are invested into making sure it's not only able to accomplish this project, but others after it, and recognize, that it's a very complicated process. And even Pacifica has indicated a willingness to start out with Kutak's documents because Kutak clearly has more experience in this than Pacifica does. So, yes, we did ask the question about levels of experience, or if you had experience in this. We did not challenge it in terms of the breadth of experience and stuff. So I guess I'm comfortable with the arrangement of two attorneys working together to make sure that we can accomplish our goals and protect the county. So, but that's just kind of where I'm at.
The last statistics I saw produced by the bond buyer, QTech's airport practice by dollar volume was ranked number 1.
No, I'm not questioning QTech's ability or any of that. I just want to have a conversation with Deanna so I can confirm that she's, I just don't want her thinking we were choosing to hire and now we've got another firm, which, was already in the works. Yes, the game changed. I just want to have that conversation.
And I sent you her contact information.
Perfect.
And I normally call her on her cell phone.
Okay.
Yeah, I don't know.
And I will say, I have not had a chance to read. We got this Friday afternoon. I was in meetings until 4:30 Friday and did some other work this weekend. So I will look at them today. So I have not had time to look through it. I appreciate you guys giving us kind of a summary of it. So I can understand as I read through it as well.
Yeah. Commissioner, Pacifica started with their own engagement letter, which was a letter to the Board of County Commissioners setting forth the terms of their engagement and what they would be compensated for. After some discussion with Mr. Maceo, we decided to, as a form, to go with the contract that we have been using for 44 years, working in their particular provisions and fee structure. Jim did a great job doing that. Gary, Jim and I have spent a ton of time on this document. I think Jim's asked every possible question he can ask about it.
I'm sure he has.
But Chairman CUNY, you ask a good question, and so does Commissioner French and Commissioner Kern's on board. In our contract with Pacific, we got a fee schedule. My question is, Commissioner French, how does that fee schedule work with this particular project that we're working on, which is unique? Because we got someone doing documents, someone reviewing documents, someone doing something else. So that has to be clear as we move forward. We can do what we want to do, but I'm looking at the total fee structure, because the fee structure assumes one law firm is doing the entire project. And so if that same fee structure applies to both law firms, that's fine, but we need to be sure we understand that, because of course the costs of the law firm are included in the bond issuance costs, aren't they? And the whole idea is to keep the costs down as much as possible because the costs are paid by the airport over the term of the bond issuance, aren't they? At least it's my understanding. So
But I want to make sure that there's one point of clarity is that our bond counsel, which is Pacific Law Group, has a fiduciary responsibility to the county and to the county only. And KUTAC does not have that same fiduciary responsibility as it relates to the county.
That's correct.
So Chairman Cooney, would you like us still tentatively to have this on next Tuesday's agenda with the idea that if your questions aren't answered, we can strike it, or what is your
Yeah,
desire?
no, I'm fine with it being on next Tuesday's agenda.
Okay.
That gives me time. I just was concerned when Gary initially said that we were going to be sending this off to Pacifica today for their approval, which is then, so I just want to have a chance to review it and to have a conversation with Deanna before it goes off to them.
Perfect.
The other item we should get before the board is the county's selection of its municipal advisor. And there's a couple of things to consider. One is the right municipal advisor for the small arms range, and one is the right municipal advisor for the airport bonds. And talking to Michael Thomas before I left QTAC, he thought there would be some utility of having a municipal advisor that had airport experience. And I don't remember the gentleman's name, but he was recommending a guy from PFM in the Midwest that worked exclusively on airports. So those two, that selection process, you don't need to go through a selection process, but those appointments need to get on the board's agenda.
Because currently we don't have a municipal advisor, correct? So yes, so again, we'd be choosing, and I think that'd be fine to just look at that.
Well, and in response to a question that Mr. Simmons put to me some time ago, we really should turn on the afterburners in the small arms range project. The broken ground, the markets are moving not in the direction we want them to move. So the earlier we can get to the market, I think the better.
And that brings also up the question that Roy had posed with the small arms range, the appointment of a Northwest Municipal advisors for that particular project versus the airport, where we probably go with PFM because they have the expertise.
Yeah, we need to have that conversation. So.
Does it make any sense to put a draft on this agreement and give it to Pacifica early so they can review it?
Yes, as long as it's draft.
Why don't we do that? Because this is complete, they've not seen this, it's different from what they sent to the county.
Okay, so they're gonna have stuff coming back and forth then on it.
Well, hopefully,
I would assume so.
hopefully not.
No, we hope not.
But if they do, we want time to deal with it. So,
Okay.
are you gonna send it? Do you want me to send
I will send it over. I'll put draft on it. We did make some changes from what they sent us, Chairman Cooney, and we did that because we wanted to be more our form, not their form, but they shouldn't have any problems with them. But we'll get it over there with the draft today and advise them to get comments back to us as soon as possible.
Can you send us their original document that they sent? So
Yes, we can.
I understand.
Yep.
The two.
Yes, we can.
What was that?
Yes. Say,
Engagement letter.
yeah.
Okay,
Thank you very much.
the capital improvement committee, you want to talk about next, Gary?
Sure, commissioners, we'd like to start looking at the establishing the formation of a capital improvement plan committee that would advise on the board on capital improvement expenditures for the general fund for the current year and do a selection process and an orderly process for them to bring before the board in an advisory capacity only. And the establishment of that committee would include 5 voting members and then Scott Chesney as an ex officio member to bring him in as it relates to GMA type of issues, so that they're working hand in hand and closely with any decisions that the committee and the board might make in terms of funding of future capital for the county. And so the issue of the formation of a capital improvement plan would require a resolution by the board. And we're hoping to get that before the board in next week's consent agenda format.
So does it need to be a resolution of the board, or can we do projects? Kind of a project charter to start out that way?
Regardless of what we do, we need, take formal action by the board. And so we just thought it would be simplest if we did a resolution. The resolution has an attachment and it sets the purpose, the committee and what their functions are. And we thought that would be simpler. We could put it in the form of a charter if that's what you like, but it would still take formal action.
Okay, which is fine. I just think we've been using the charter process to kind of
The state
establish.
auditors would probably be more comfortable with auditing to the board resolution.
Yes, which is partly what I think I want to make sure that it's the board that is setting the capital facilities plan. So I actually don't want to give the auditors more reason to be auditing just internal policy, kind of an internal policy. It's like, I don't think that we need that because it's really to try to set up the capital facilities plan, which comes before the board, which is what the auditors should be auditing to. So that's part of, I guess, my
Right,
thoughts.
and their rub is that if it's not a recommendation by the CIP committee for the general fund, then they question the propriety of the county expending those funds, especially as it relates to REIT.
Yep.
Madam Chair, your point is well taken. We've been very cautious in setting this up. We've coordinated with the planning director, Mr. Chesney, and his legal counsel, Jessica Pilgrim. And you are correct in what you're saying. The county commissioners are entirely responsible for the adoption of the capital facilities plan. And a component of the capital facilities plan is the capital improvement program. And that's what we're trying to address here, because previously, the state examiner has questioned the expenditure of REIT monies because they're not included in the capital facilities plan. And so
Right, at the higher level, not
you're
at the lower
correct.
level.
And so we've been very cautious in the document that Mr. Petrovich has prepared to make it clear that the committee is set up, is going to make a recommendation to this board. You make the ultimate decision. But when you make that decision, you have to take into consideration your capital facilities plan and everything you have to go through to do that. So we believe that the particular committee which you're setting up is simply advisory. It leaves in the county commissioner's hands how you expend those monies, whether it's general fund monies or REIT monies for capital improvement project, your capital improvement project. But as Ms. Pilgrim will tell you, in your capital facilities plan, you list capital improvements and the particular funding sources that they come from. And so you're going to have, whatever you do in the capital improvement plan, you're going to have to implement in your capital improvement facilities plan. And so it's been very carefully drafted so that we don't step on the GMA hands as we move forward. So I think we feel very comfortable that we haven't tied your hands, that you still have the authority under the Growth Management Act that you're supposed to have.
So I'm more interested in what does it take to add something to the plan? How can we amend it without going through a 6-month process that kills an opportunity?
I think Jessica Pilgrim can address this, but unfortunately, Commissioner French, if we modify the funding source for a capital improvement, we've got to amend our capital facilities plan. And we have learned then that means that it has to go before the Planning Commission because they determine the capital facilities, and the funding sources, and then it would come back to the board. So, in answer to your question, Commissioner French, unfortunately, there's no quick fix to amending the funding sources to fund a capital facility in your capital facilities plan. And if I have misstated that, Jessica Pilgrim, please, if you could, Jessica is a senior attorney that handles growth management issues. And if I've misstated that, please correct me, Jessica.
No, you're spot on.
So we have ARP money made available to build out infrastructure. And there is a federal process that we have to go through to be able to comply with that. And so what you're telling me is I have to go through a whole nother 6-month process through the Planning Commission on top of what I've required to do for the federal government to be able to build infrastructure this community desperately needs.
Well, it depends. So the capital facilities plan has to identify improvements necessary for development. So if you're doing something above and beyond that, it doesn't necessarily have to be identified in your capital facilities plan. The capital facilities plan has to address basically the floor level of your LOS. If you're going above the LOS and you're installing a school that didn't, I know we don't fund those, but just for easy example, you're putting in a school that's not necessary. It's above our LOS. You don't have to identify that in your CFP. You can just expend it and identify it in the CIP. If you're using money that's necessary to meet the floor, like you're not meeting an LOS, you have to address that in your CFP. And then the process takes a little longer. So it kind of depends. It would probably be issue specific, but usually where you get the complaints on your CFP, right, is if you're not meeting your LOS. If you're going above and beyond, you know, one, you probably don't have to identify it, but two, just frankly, like who's gonna sue you on going above and beyond is the, you know.
So I'll use as an example, the project up in Commissioner Kearns' district with regard to Whitworth Water District and providing, you know, piping to be able to expand their service to, you know, areas that are desperately in need of water and stuff. So are you telling me that in addition to the feds, I now have to put that through my capital facilities plan for the county to be able to make that investment?
So it depends. And I should add the caveat of some funding is linked to putting it in the CFP. So for example, REIT funding. So if you're going to expend REIT funds, the REIT statute requires that it be in your CFP. So that if whatever funding source you're using requires it be in your CFP, then you have to put it in the CFP, even if you're exceeding the LOS, and it has to go through that process. And I want to say it can be faster, but typically is not. And I believe the statute still requires you to only amend your CFP once a year, with the exception of you can amend it again if you're also passing your budget later. So say we amended the CFP in June for some reason, and then you do the budget in December, you could technically amend it a second time to match your budget in December, but it still has to go through the Planning Commission. But that can be done in as little as maybe 2 months with getting it on the agenda, noticing it, going in front of them, and then noticing it again and having you guys adopt whatever the Planning Commission says.
So in order to spend the REIT dollars, it has to be, yes, in our CFP, correct? But are there other requirements that are requiring us to have this capital improvement committee?
So they're distinct, they're different. The capital improvement committee is to advise on all things that the budget office kind of identifies as capital improvements. And we've discussed this before. For example, the roof on the courthouse, if it needs to be replaced.
So they're really the advisor to the budget office.
Yes.
And the budget office then, as part of the budget cycle, is bringing forward to us. That's what I just don't want to get, where this capital improvement committee is now our committee that we have to rely on. Because I'm relying on the budget office, and we still are going to make decisions that may not be in agreement with what the capital improvement plan committee is going to do, just because, I mean, stuff changes all the time. I mean, we know that there's stuff that the roof may start leaking, and so we got to fix it today versus 2 years from now that we have planned. you know, so, I mean, that's where I just don't want to get down the road, because that's, the auditors are not auditing to, they're auditing to what the commissioners are putting, saying they're going to spend the REIT dollars on. And that those REIT dollars expenditures are planned for in the capital facilities plan. Has nothing to do, in my mind, that the auditors are looking at what the capital improvement committee is doing.
For example, we amended your capital facilities plan 2 years ago to include REIT monies to be used for your small arms range and your training facility. And we did that pursuant to a specific project because we knew you were going to use those REIT monies, and we knew the state examiner was going to ensure that your capital facilities plan identified that as a funding source, because if it didn't, you couldn't use those monies until you amended the plan. And we did that.
Yes.
And so in some instances, the items that the capital improvement committee is going to recommend don't need to be in the capital facilities plan.
Really?
Go ahead.
So can we limit the scope of the capital facilities plan and the committee to just REIT dollars? And how we allocate and use REIT dollars or other dollars that might be used for these kind of activities, and not make it universal to all funds that are going to come to the county?
So Al, when I first joined the county as the chief deputy auditor back in 2015, there was a committee that was a task force that was formed to look at what the capital needs of the
Yeah, it was done under Bob Wrigley.
yes.
Yeah.
And so to me, that's what, as a commissioner, that's what I'm looking for. I don't want a formal process. I mean, a formal committee with voting members and non-voting members, because I think in my mind that makes them, you know, as I was then an employee, makes me think that I'm having more influence than I do, because it's truly the commissioners, the ones that are making the decision. And so that's my concern, seeing it from the other side, that, I mean, we can have a committee get together, a task force, and look at this and come up with like a 5-year, 6-year plan as to what we think. Because those departments actually know more what their needs are, and we're not getting there now, and I know that. But it's still up to the commissioners to make the decision based on what we know at a different level, because the commissioners are seeing it at an umbrella level versus at a siloed department level. And
Are you aware of who the committee members would be on the CIP committee?
well, no, I have not seen the
Well, Scott is a member of the committee, for example. So he'd be leading the charge in terms of developing a structure and a criteria factor for assessing any of the requests that come in from all of the departments, along with the director of the facilities, Scott Chesney. I think we have, who else is on that board?
But can we set it up as just having a committee come together to do this? I mean, I don't feel that we need to have a formal.
Only from the context of best practice. You can not have the committee, you can have it in any iteration you want. We were just trying to put forward a practice, and Scott was promoting this in terms of best practices.
So I see two different initiatives here that are getting meshed together, and I agree with Mary. I want to keep them separate. You know, what we need to do from an operational standpoint within our budget, you know, to deal with the campus, to deal with department needs, to deal with, you know, vehicles that are needed by different departments and stuff. That's something that, you know, staff needs to inform us as to what's the best thing. But what I hear Jessica talking about is a capital facilities plan that talks about infrastructure to implement our comprehensive land use plan.
Yeah, that's very complicated.
That's a different animal. And I really don't want to see those two joined in any way.
Well,
kind of a deal, because
we don't want them joined in any way. However, as we found out, Scott, in our last meeting with Jessica and with Scott, that there could be overlapping areas, and we've got to be aware of where those areas overlap and discuss how to address the issues, right?
Yeah, so what we were finding is the initial intent was for the departments to come together in this committee and kind of say, hey, you know, Parks is like, hey, I need a new park over here. And, you know, maybe judges are like, we need a new courtroom, and get together and kind of rank those in a priority as a group. But the issue is you have that added layer of, well, parks is actually an element that's required to be met with the CFP. So you have to give them priority because of the CFP and our LOSs. So then it's just the added layer of, well, these, if you're going to create that group and if you're going to create this prioritized list, some of them are overlap with our CFP, and those need to take priority because we're mandated by law to install a park where we wouldn't be mandated to put a new roof on the courthouse. So that's the kind of balance we were trying to strike, is get this recommendation from the departments that would assist the board in ranking the priority of these capital improvements while also meeting the CFP mandate. So that's where it's getting.
So that decision-making, I think happens at this table, not at the committee level. So if we've got two committees that are coming up with a list of requests, then I don't want you guys messing that list together. I want that to be a decision of the three commissioners and stuff. And so if there's two groups that come to us asking for money, that's a good day as opposed to all the others. So I would rather not mesh the two together and have them be independent and come to us, as opposed to somebody saying prior to it getting to us, well, this is the priority. Nobody prior to us has the authority to say this is the priority. That's up to the three of us to say what the priority is.
And we don't
Is
want
that
to,
fair?
yeah, and because what we don't want to have happen is have this, when you have a formal committee, then people think, okay, it's going to get funded if they approve it. And that may not happen. And that's the concern I have, having it being a formal committee versus a task force, saying, we want to really start to take a look at this and come up with a plan. Because as we know, I mean, I've got people asking all the time about space in the courthouse, and we need space and all of that. And we're waiting for the space study. So I mean, the commissioners haven't even seen the space study to even start to inform on what our thoughts are as to what we see as priorities too. So, I mean, so there's so much moving right now that I think, and with ARP dollars as well, that having a formal committee that then we feel like we're out of, I mean, because quite frankly, I would say, even though it's advisory and it's coming to us and all of that, we're going to feel like I will just say how I feel, that I'm now taken out of the decision process because all this time and effort has been put into this. And I think it needs to be prefaced, and this is based on, how I saw it in 2015, that we're coming together to try to help provide a prioritized list for the commissioners to help guide them. I think when you get into voting and non-voting, then people think they're more attached to that. And that if we don't decide to do it based on their recommendation, that then it's going to be, oh, the commissioners don't want to fund us. And that's not what we're trying to do. I mean, there's just so many moving pieces at this level, at this table, that I just don't want to get put into a position that we're not making good decisions.
And the way it's set up, I'm sorry, Scott, excuse me, go ahead.
Oh, words matter, and I'm hearing directly from both of you commissioners to make sure that our words aren't getting in our way of ensuring that there's clarity that the board of county commissioners has the ultimate authority and is the one who are approving the plan, elements in the plan, how they're going to get funded, what the prioritization is. If just taking a step back, our intent was to have a framework whereby we can receive the various capital needs that are occurring in the county today. And we can work on identifying potential sources of funding, potential prioritization, where they would fit in year 2023, 2024, 2025, so that it gave the commissioners a framework by which you could see the buckets, you could see the available funding and funding sources to be able to inform on a decision process for you. It was never meant to take that process or take that decision-making from you. It was really just to create a structure by which, how do we get groups of people together so that we could receive these various courtrooms, courthouse facilities, software investments, parks investments that are needed so that you could see a holistic picture, combine that with our water, our sewer plan, with our transportation plan that already exists today, which you all see each year. You all have the approval authority in that. And it was really to marry those other two together. It was trying to take what we're doing in those other areas and bring them together. So that was our intent. And I think we could go look at, the voting, maybe not have that sort of stuff in there, but just have, here are the individuals on it who, again, making sure that it's clear that they're advisory, they're just bringing forth they're gathering the information so that we can bring it back to the commissioners, have a discussion, dialogue. And I see this to be multiple touch points. This isn't a December 1st, here's your CIP. This is a early on in July, August, September, as it's continuing to evolve and grow, and we're bringing the information together. So you have multiple touches with it. You're giving feedback as to know that I think this is a higher priority than that one. Great, we can make some changes, move some things around. The thing that's important with a CIP, the capital improvement program, is kind of from a best practices standpoint. I look at that document to be informing pretty clearly as to what is going to be included in next year's operating budget. The out year, 5 years, are placeholder items that we believe need to be accomplished, but no one should look at that document and say that is exactly when that's going to occur, because needs will change, funding availability will change. We may have put something in there that we were chasing some federal funds or some state funds, but it's out a couple of years because we don't know if we're going to receive those. But it's really important for us. And if we receive them quickly, the board wants to be able to have the ability to move that up from the third year to the second year, or vice versa. So that's the concept of what we're trying to do. And I think with what Jessica has highlighted to us is we do have to have some harmonizing of the capital improvement program to be aware of what might be being informed to the GMA, because something might have to come into the CIP that committee didn't have awareness of. That was the connection with Scott, to make sure that we have the awareness and connection with what may be informing on the CFP.
So the CFP, I can amend once a year, right?
Or with the budget.
Twice. Yeah, or with the budget. So you can do it once
With the
independent
budget
and then
or
with the
once a
budget.
year. So I'm locked into that puppy for a year.
Kind of.
And amend it is challenging at best. It might only take 2 months if I'm in the cycle, but if I'm not in the cycle, I'm, well, there's a term for it. But the CIP is a totally separate animal and stuff. So if we could keep these two conversations separated by CIP and CFP, then I get a lot less nervous. But when things start, otherwise you end up throwing everything into the CFP with an expectation that you can fund it. But if you can find funding for it, great. But if you find funding for it and it's not there, again, you're SOL. It's just, we would defeat progress with the process, and that's unfortunate.
But
And
for
so
the
that's what I'm trying to protect us from.
We understand, Commissioner French, what for the REIT issue, we might not be here because Commissioner Cuny, just as you said, the state examiner says, Mr. Macio, does your capital facilities plan indicate that you're going to spend REIT monies for this particular purpose of this item, which has to be in your capital facilities plan?
Right, which I want to keep the state auditors at that level.
Exactly.
And I don't, if we pass a resolution, then that's now in Lease County law that they will audit to. And I don't want to do that because I really want them to stay at the RCW level of what are we legally required to do. The rest of it is internally how we choose to then pull that information forward. And so that's why I don't want it to be a formal resolution.
Yeah.
Because that puts it into another level of audit.
Yeah, so
And I don't think we need that because it's truly at this table that those decisions are made.
Yeah, can't you two just do this under your authority?
We can create a operating, kind of a policy, if you will, that sets forth the intent of this group. One of the benefits we thought was if the board adopts in some sort of fashion, whether it's a resolution or a policy, it signals to the county as a whole how you want capital requests in a variety of shapes and sizes to be received and considered for incorporation in.
So, but then that's the discussion that hasn't happened here, that you're already now making, resolution on it. And so again, so that should be a conversation with all of it, the three of us and you and Gary, to say, how do we as commissioners want that to come together for us, and Jessica, as well, so we're meeting all the requirements that we need to, so we're getting an understanding from the departments, but that's the conversation we need to have before we do anything else.
Okay.
Because then we're happy to go speak to whatever that group is, or to put out a statement that this is what we're hoping to accomplish by you coming together. And it's just coming together. It doesn't have to be a formal, I know best practices are one thing, but we can certainly try it this way first and then formalize it as we go along. But I guess that's where I'm at. I don't know, Al. We haven't had that conversation yet amongst the three of us with you.
Yeah, if you need something to validate the process, I think I think we could, as a board, authorize you to proceed with creating the process. So that you've got some validation as you talk to the department heads and everything. But that doesn't say whatever the outcome is, blessed and holy water kind of deal, and it's something that we're bound by. It's just advisory to the board so that it maintains our flexibility in terms of adjusting as we see the priorities. Does that get you where?
Yeah.
Yeah, because I mean, I understand staying out of the auditors. The minute we somehow, adopt that as a policy of law, we're done.
Okay. Let us go back with the feedback that you've given to us. We'll do some honing of this, and we'll come back and kind of see if we meet the mark, and again, kind of reiterate what our intent is and whether it's
Right. And yeah, I would say come back, I know we're short on time today, but it's like, so I think have that conversation to say, what is our intention? What is our need? And yeah. Josh, I'm sorry.
I'm tracking with both you, Al and Mary. I'm in the same boat. One of the things that really stood out to me, Mary, that you referenced earlier is about, if an advisory committee takes that vote, it's amazing how fast people forget what an advisory vote is. That word advisory tends to get lost too often. And some people think, well, this committee said they want you to do this, and if we don't do it, it's like, well, it was advisory. So now I share the exact same concerns that both of you do. I'm fine if there's a group that wants to send a list of things to say, hey, here are some needs, or here are some concerns. And we can evaluate that at our level. But so yeah, no, I'm tracking with both of you.
We can fold it into the budget process as just a normal workshop type of thing. And just as these things come up, address and engage with the board in workshops to just go through the process on an ad hoc basis each week when we meet, when we're getting close to the budget deadline.
Yeah, I think though, I need you guys to come back and let's have a little bit more discussion on that. Whether it's part of the budget process or we have you do it as a group, and to get, I haven't seen the resolution, so I don't, so it'll be helpful to have that, to see it as to what your thoughts were. But I think we're just seeing that we have different thoughts than you guys do, and we haven't come together on those thoughts yet. So they just need to come together. And
we've been operating without one for how many years?
Right. No, which I know. Like I said, that's why in 2015, I was part of the task force to try to come up with what that would look like. So I completely understand it. But it is interesting being on that side and then being on this side, how it's a whole different thought process. And we have, just different, that's why I say we're kind of that overall umbrella, really seeing it from that perspective versus the departments are seeing it from their perspective, which you want, which you need. I mean, because we don't have that perspective. So we need all that coming together.
Yep, we understand. Good feedback, important for us as we're kind of continuing to think about the shaping and framing of this.
Okay. Okay, so we are at 11:39. Does anyone have a hard deadline? Josh, do you have a hard deadline? Okay, so I know Erin definitely wants to give an announcement. So, Erin.
Good morning, commissioners.
Good morning, our fair director. Why don't you have an announcement for us today?
I do. Ron, are you able to share our slide, please? Thank you. So fair planning is getting exciting, and we have booked 3 concerts for this year's fair. And the first concert announcement is coming out this week, tomorrow, and that is R&B artist Nelly. He has been very popular at fairs across the country, and we're looking forward to hosting him at the Spokane County Interstate Fair on Thursday, September 15th. We will be rolling out our other 2 concert announcements, one next week and one the week after. So if you're really excited and dying to know, please give me a phone call and I can fill you in advance on who we will be announcing in the weeks to come.
Awesome. And then I see you also have, is that your new logo for the 2022 fair?
It is a super fun logo. We feel like this year, all systems are a go. So all systems go is our theme this year.
Great. Well, that's exciting. And then exciting concert announcement.
Thank you.
Congratulations.
Yeah, it's feeling real. We are just months away from hosting the fair and we're excited.
And so you said tickets are going on sale?
This Wednesday at 10 a.m. for Nelly.
Okay, very good.
Great.
Any comments from my fellow commissioners? No. Okay, great job, Erin. And then we'll look forward to each week. The next 2 weeks, you'll be back to give us another announcement.
We can get that on the schedule. Yep.
Very good. Thank you. I think it's kind of fun to get to announce here.
All right. I appreciate the opportunity.
Okay. Thank you. Thanks for your patience today too with our time.
My pleasure. Thank you all. Have a good day.
Okay. Okay, so next we have.
See, Colin, it pays to show up. You just scoop everybody.
So next, Arian, there we go.
Good morning. This will be quick. I just wanted to give you an update on the grant submission for funding from the Commerce Opportunity for Refugee Resettlements for those fleeing the Ukrainian crisis. They came in 2 tiers. Tier 1 was as you got in, they allocated funds. We were able to submit a request last Thursday, and within 12 hours, we were notified that our $1 million ask was accepted. So Erica and I will be meeting with Commerce to finalize that award today, and you should see that on your agenda for next week. I just received the okay from the Ukrainian Refugee Coalition for the Tier 2 scope, which has a few more requirements on it to go ahead and submit that. That has a deadline of this Friday, and that will be for the tune of $2 million. The Tier 1 has to be expended by the end of this fiscal year, which is June 30th. Tier 2 will be for next, it doesn't have to be expended till June of 2023. So the scope is primarily just an ongoing expansion of the services in Tier 1, but just for a longer duration. And once again, once those funds are received, Spokane County will work on a direct allocation. No RFP is required to eligible resettlement firms to get that done. So those are the two things in motion this week. Scott, anything else you want to add to that?
No, just, I mean, great work with you and working with the community on this one. It's exciting news.
Mm-hmm.
So Erin, a question for you. So we got acceptance that we've got the first $1 million, but it's got to be spent by the end of June of this year, which is not very long. Does it allow for you to go back for previous expenditures prior? Is there a time frame for expenditures?
It does allow for reimbursements. However, I just received word from Boris, who briefed you last week, that they are actually in the final arrangements of a midterm lease agreement with a owner of a hotel that wants to convert eventually that hotel to apartments, but they are actually going to lease it to those serving the Ukrainian refugees for a duration of time at a deeply reduced monthly rate to allow for that. And I think they're wanting to commit as much of that $1 million as possible to that dedicated location for housing assistance. So once again, they've already got things primed and ready to expend that in the next month and then go forward. But sorry for the long answer. The short answer is yes, they can go back, but I'm not sure how much that will be applied.
So they'll be able to spend that before the end of the time frame.
In fact, he actually told me this morning that Commerce has said they have unused funds and they're accepting amendments to budgets for tier 1. This is very abnormal for Commerce. So we actually might even amend our tier 1 accepted budget to an increased amount because we just received word that they'd like to give us more. So all of this is almost real time in solidifying. So it'll be settled by the time we get the resolution before you.
Okay, great. Thank you very much.
Thank you.
Okay, so that is going to take us to Jessica Pilgrim and Scott Chesney, which is pending potential litigation. Jessica, I'm going to let you speak to it and let me know who's going to be in.
Yeah, so I'll just set the record first. So this will be an executive session on the McKee mediation, in McKee litigation matters. And it's regarding a recent ruling by the Growth Management Hearings Board. And we'll discuss the pros and cons and the legal pathway on possibly appealing. So in that executive session will be the board, the executive management team, myself, Scott Chesney, possibly Mark McLean, and that is it.
Okay, very good. And how long do you think it'll?
It will be about 15 minutes.
Okay, 15 minutes.
And we will need to come out and take action.
We will. Yeah, okay, so we will not be adjourning yet for the day. So we anticipate 15 minutes and we will come back into open session to take action.
One quick miscellaneous, just for the two-touch, next week you'll be seeing, if you want me to, the GSI reached out for these called the Abilene Award, formerly the Air Mobility Command Community Support Award. And they're looking for a lot of support from the commissioners to put in for our community support of Fairchild. And so with
Do
the
they
head
need
nod,
that sooner than later or?
and next week should be fine. I just
Okay.
needed to get the head nod from you guys and we can present it next week.
It's May 6th. Do May 6th. I'm in contact.
What is May 6th?
We'll work together.
So we do need to do it this week then.
Yeah, why don't we go ahead and make a motion now, and then that way we don't stand in the way of getting this done. It's important for the community. Madam Chair, I would move that we authorize the drafting and signing of the letter and other than an open public meeting, to be signed in other than open public meeting for representing support for Spokane County for Fairchild Air Force Base and its efforts to once again be the recipient of the Abilene Trophy for 2022. Correct.
And to be signed by all three commissioners.
Be signed by all three commissioners. Yes, thank you.
I will second the motion.
Okay, I have a motion and a second. Any further discussion? Seeing none, all those in favor, please signify by saying aye.
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 Motion passes unanimously. Okay, so it is now 11:48. It will take us a couple of minutes to get into executive session. So I'm going to say 11:50 will be when we start executive session, and we will come out at 12:05 is what we anticipate. Okay. Okay, welcome back. It is 12:09. I will say I'm extended for 4 minutes, partly just try to get back on the computer. So with that, I will look to my fellow commissioners for action.
And thank you, Madam Chair. Just as a recap, we met regarding the Mickey mediation matters, and we discussed the growth management hearing board's ruling on the motions to dismiss on the Mickey consolidated matters 051, 007, 14-1, 002, 0002. No action was taken while in executive session. The question before the board is whether the board wishes to appeal those motions to dismiss. And if so, the motion would be to do a direct appeal of the growth management hearing board's ruling on the motions to dismiss in the Mickey consolidated matters 051, 0007 and 14-1, 0002.
So moved.
I will second the motion.
Okay, I have a motion and the second as stated by Jessica Pilgrim and moved by Commissioner Al French. Any further discussion? Seeing none, all those in favor, please signify by saying aye.
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 Motion passes unanimously. Thank you very much. That will end our 9 o'clock strategic planning meeting. It is 12:10. And we will reconvene tomorrow for our Tuesday 2 o'clock consent agenda. Thank you very much.